In the winter of 1986, federal prosecutors unveiled their pivotal strategy. Prove beyond a reasonable doubt that Tom Manning, Ray Levasseur, and their co-conspirators had legally conspired to carry out a series of politically motivated bombings. This wasn't about lone actors. It was about a coordinated, decade-long underground movement that viewed itself as a revolutionary cadre. Before we dive in, don't forget to like, comment, and share this video for more shocking secrets, undercover missions, and high-level twists. Help us keep revealing the untold stories that others dare not tell. Under U.S. federal law, conspiracy charges are built on an agreement between multiple individuals to commit a crime. In this case, bombings using explosives in interstate commerce. Proving conspiracy doesn't require that the bombings were successful. Rather, it requires evidence of intent, planning, and at least one overt act toward execution. In Manning's case, prosecutors argued that the UFF had taken multiple substantial steps, including construction of bombs, planning target operations, purchasing components, and practicing delivery methods, all clearly showing criminal intent. Federal prosecutors described the UFF as structured, disciplined, and ideologically driven. Their indictment claimed, a formal agreement existed among members from 1975 to 1984 to use explosives. The group carried out at least 20 bombings and 10 bank robberies in the Northeast and Ohio, targeting military contractors, courthouses, corporate offices, e.g., IBM, Union Carbide, and symbols tied to U.S. foreign policy and apartheid regimes. Evidence included communiques claiming responsibility, audio recordings, photographs of surveillance, purchase records of timers, gasoline, and vehicle rentals, plus first-hand testimony from surviving members and witnesses. Taken together, the prosecution asserted that their conspiracy wasn't rhetoric, it was a war plan. The U.S. District Court documented multiple overt criminal acts, including bomb manufacturing. Safe houses were used to assemble devices using fuel, fertilizer, timers, and metal casings. Reconnaissance. Members scouted targets physically and via photographs, studying entry points, security cameras, and evacuation routes. Material procurement. They bought timers, wiring, fertilizer, gasoline drums, and fake IDs. Field notes and bank transfer records supported the chain of purchases. Execution of bombings. More than 20 distinct bombings were carried out. Though they issued warnings to avoid fatalities, property was destroyed, including a 1976 courthouse bombing that injured 22 people and caused one amputation despite warnings. Bank robberies. Despite being separate crimes, they funded the bombings. These robberies themselves were overt acts supporting the conspiracy. All these steps created a narrative of intent and action, meeting the legal threshold for conspiracy. During the Ohio 7 federal trial, Justin U.S. District Judge relied heavily on internal communications and witness testimony. Ray Levasseur acted partly as his own lawyer, delivering fiery reflections in court, not about innocence, but about ideological justification. Tom Manning often let silence speak for him. His courtroom demeanor, stoic, defiant, sometimes contravened standard procedure. He contended that they were political resistors rather than criminals. But the jury saw the evidence differently. In March 1986, the jury convicted Manning, Levasseur, Lawman, Williams, and others on conspiracy to commit bombings, use of explosives in interstate commerce, firearms possession, bank robbery conspiracy. Combined sentences ranged from 15 to 53 years, with Manning receiving life for murder and the conspiracy charge adding serious weight. The conspiracy charge anchored the legal case. It framed the bombings not as isolated incidents, but as coordinated strategy with ideological purpose. Defense attorneys challenged the sufficiency of evidence, arguing many acts were mere contemplation, not intent. However, precedent from cases like United States versus Whitehorn showed courts generally allowed broad interpretation of conspiracy. No successful appeal overturned or dismissed the conspiracy indictments. Later, some defendants faced separate RICO and seditious conspiracy charges, but not for the same bomb plot. In 1989, a mistrial occurred on separate sedition counts for some members, but the conspiracy to bombings verdicts held firm. Legal experts call this case a turning point. It demonstrated the government's ability to prosecute politically motivated violence with broad conspiracy statutes. The application of seditious and RICO statutes against domestic ideological groups. That even if bombings don't kill, conspiracy to use explosives can result in multi-decade sentences. For the UFF defendants, the conspiracy charge became the legal hinge between activism and felony. It made every bomb, every meeting, every purchase part of a criminal design. To the court, conspiracy to commit bombings meant planning, coordination, and execution with political purpose. To the UFF, it was tactical resistance. In the eyes of the jury, it was criminal intent. Between 1975 and 1984, Manning and his group organized events not as isolated acts, but as a decade-long plan to strike what they saw as imperialist, racist, and corporate power structures. The jury delivered their verdict in line with that assessment. Tom Manning, Raymond Vassar, and their co-conspirators were convicted on the core federal charge of conspiracy to commit bombings, supported by dozens of overt acts, spanning purchases, bomb construction, reconnaissance, explosives deployment, and political communiques. This conviction formed the foundation of their sentences, representing how the U.S. justice system handled domestic political violence during the Cold War era. Between 1975 and 1984, the United Freedom Front, UFF, operated across several states, frequently crossing state lines. Whatever they transported, whether bank loot, explosives, or safe houses, often involved vehicles taken unlawfully or registered under false identities. For federal prosecutors, this formed the basis for charges under interstate transportation of stolen vehicles statutes. While the UFF never conducted an express car theft ring, their habitual theft, use of stolen or fraudulently registered vehicles, and interstate operations fit legal definitions of transporting stolen vehicles or conspiracy to do so. Under federal law, 18 U.S.C. Section 2312 and Section 2313, it is a crime to transport stolen vehicles or goods costing more than $5,000 across state lines. For the Ohio 7, they drove stolen cars acquired through robbery or identity fraud, operating across state jurisdictions, e.g. from New York to Ohio, used in further criminal acts, transporting cash, explosives, safe houses, and intentionally shifted these vehicles to support their underground network. Although not tried under a dedicated vehicle theft statute, these facts align with typical stolen vehicle transportation charges used in similar multi-state conspiracies. Federal investigators tied the Ohio 7 to stolen vehicle logistics through license plates changed or fake IDs used to avoid interstate detection, vehicles found in safe houses across state lines after bank robberies, rental cars taken from one state to another for bomb transport and safe passage, cars used during violent encounters, e.g. Laminaco traffic stop, not registered to the occupants. Each act was enough to satisfy elements of interstate vehicle transport statutes. Law enforcement saw a pattern. Safe houses in multiple states, New York, Ohio, Vermont, Massachusetts, with different cars associated with them, stolen or cloned plates and fake registration, allowing vehicles to cross state lines undetected, routing bombs or bank money across jurisdictions using these vehicles, and key arrests near state borders, suggesting strategic movement. This interstate mobility relied heavily on stolen vehicles or those registered under false names, making transport a relevant charge. In federal prosecution of the Ohio 7, the courts treated all these acts as part of a larger conspiracy, tying in stolen vehicle transport alongside bank robbery, explosives use, and murder charges. While no separate vehicle transport sentencing table is publicly available, the prosecution's unified indictment underscores that these movements were essential to sustaining UFF's operations. Expert lawyers in violent ideological cases consider this charge critical, not just for the theft itself, but as a logistics offense that enabled interstate criminal enterprise. Similar federal prosecutions have hinged on stolen vehicle transport. A multi-state car theft ring in New Jersey, 2024 to 25, led to charges including interstate transportation of stolen vehicles, with sentences up to 10 years per count. In Ohio, chop shop conspiracies involving stolen vehicles dismantled across state lines earned multiple convictions and long federal sentences. These modern parallels help us infer how prosecutors approached the UFF case, subsuming vehicle misuse into broader conspiracy charges. For UFF, stolen vehicles were mobilizers, moving cash, bombs, and fugitives. Interstate transport blurred lines between isolated attacks and regional terror. These acts tied UFF firmly into federal jurisdiction, not just local police interest. The prosecution linked these transportation acts into its core case on conspiracy, emphasizing the UFF's mobility as structural proof of coordinated crime across state boundaries. Though sentencing records highlight charges of conspiracy, armed bank robbery, explosives, and murder, the stolen vehicle aspect was woven into the narrative, justifying federal reach into every safe house, abandoned car, and route UFF used. Though not always counted as a separate sentence, it reinforced the depth and geography of their criminal enterprise. The interstate transportation of stolen vehicles charge may not appear front and center in court documents, but it underpinned all of their regional movements. Their logistical network, from safe houses to bomb deployment, depended on cars stolen or fraudulently registered and used across state lines. It elevated their crimes from isolated incidents to a federal conspiracy spanning multiple states. Without that capability, the UFF couldn't have sustained nearly a decade of militant operations. It wasn't just who they were, it was how they got around. Don't forget to like, comment, and share if you believe in the power of words and silence. This is where the story begins to twist. It wasn't the robberies, the fake IDs, or even the murder that broke the case wide open. It was the bombs. And not just any bombs. We're talking about a calculated campaign of destruction across state lines. The feds called it terrorism. The UFF called it war. And in court, it would all come down to one thing: who controlled the blast. By the time the courtroom doors swung open in 1987, the United Freedom Front had been hunted across 5 states, linked to over 20 bombings, and branded as domestic terrorists by federal prosecutors. But it was this one charge, use of explosives to damage property in interstate commerce, that the U.S. government used like a sledgehammer. Because with this charge, they didn't need to prove intent to kill or even successful destruction, just that the bombs were placed, transported, and meant to disrupt interstate businesses. The bombs weren't tossed into the air like chaos. They were strategic. From IBM to South African-connected corporations, the UFF planted devices with political purpose, aimed at institutions they claimed profited from oppression. But the Interstate Commerce Clause gave the government a legal backdoor, turning each explosion into a federal crime. Example: a UFF bomb exploded at an Exxon facility in New Jersey. Nobody was hurt, but Exxon's gas shipments traveled across state lines. That detail was enough to federalize the charge, and the feds ran with it. The courtroom was dense with tension. White heavy checkmark photographs of twisted steel. White heavy checkmark witnesses from the FBI bomb squad. White heavy checkmark chemical residue reports. White heavy checkmark shrapnel analysis. One by one, the prosecutors painted a picture, not of chaos, but of organized bombing logistics. They showed how Tom Manning and Ray Vassar allegedly drove across state lines with explosive materials, researched their corporate targets, timed detonations to send political messages. An FBI agent testified about a cache of dynamite found in a Massachusetts safe house linked to the UFF. Traces of that same material matched remnants from bomb scenes in New York, Virginia, and Connecticut. But what truly turned the jury's heads? A handwritten note recovered from a UFF member's apartment, listing potential bomb targets, including corporate addresses with supply lines crossing state borders. The ink had barely faded. The defense didn't deny the explosions. Instead, they framed it as political protest, not terrorism. This was not wanton destruction, one attorney said. It was a targeted resistance against imperialist interests. But that defense stumbled in the face of surveillance video, expert testimony, and a chilling intercepted phone call, where 2 members allegedly joked about lighting up capitalism. What chance did a defensive ideology have against federal law wrapped in steel-tight evidence? The charge carried heavy weight. Under federal statutes, using explosives to damage interstate commercial property was not just a crime. It was treated as an act of terrorism. Convictions meant mandatory decades-long prison sentences. No parole. Terrorist enhancements to all other charges. And that's exactly what happened. Tom Manning and his comrades were convicted. Their involvement in the bombings used as legal leverage to stack sentences up to 80 years in some cases. It wasn't just the bombs that blew up lives. It was the law that followed. To this day, Use of explosives to damage property in interstate commerce remains a cornerstone charge in modern terrorism cases. From domestic militias to international threats, the U.S. government uses it to slam shut the door on bomb-related activism. But for the UFF, this wasn't just a conviction. It was the end of a movement, and the beginning of a debate that still lingers. Exclamation mark, when does protest become terrorism? Exclamation mark, can a cause justify destruction? And most importantly, exclamation mark, could the next political bombing case be tried the exact same way, 40 years later? If this story shocked you, hit that like button. If you think justice was served or silenced, drop your thoughts in the comments. And if you want more courtroom stories where law and ideology collide like dynamite, subscribe to Daily Crime Discoveries. Because the truth, it's still ticking.